Hi, good afternoon, and welcome to the Divorce Like a Pro series. This one is entitled Understanding Your Rights as a Grandparent. We're so happy to have you all here today. I hope you find this information useful and informative. And we will be having time where submitted questions are answered while we are live today. If you have not submitted a question in advance, feel free to do so. But I'm going to go ahead and get started because we are right at noon and it's our starting time. I want to make sure we get the most of our time together. So let me first by starting with my introduction. I'm Debra Whitson. I'm a New York-based family law attorney. I'm also a mediator and I'm trained in collaborative divorce. I'm a certified divorce specialist and the author of Divorce Like a Pro, A Better Way to Break Up, which you can get on Amazon or find by visiting our website, www.WhitsonLawFirm.com or www.mediatedonlinesolutions.com. So welcome to everybody. We're so glad that you're joining us today. I want to start by a couple of legal disclaimers. So first of all, let me say once again that I'm a New York-based attorney. I'm only licensed to practice law in New York. I've been an attorney in New York for nearly 30 years. I know New York law very well. But if you are in another jurisdiction, including any other state or any other country, you're going to want to make sure that you get specific advice on your specific situation and the rules and the procedures involved in your jurisdiction because they're most likely going to be different than they are here in New York. Also, nothing said or communicated or answered in response to submitted questions is considered legal advice, and there is no attorney-client relationship. Obviously, the questions that have been submitted so far are anonymous, and they'll remain that way unless you choose to submit a question in the comments section as this event is going on live. So with those caveats, I want to dive right in. I'm going to start by telling you a little about how New York treats grandparent rights to visitation or custody of grandchildren. So in intact families who are happy and harmonious in their relations with extended family, grandparents do have access, typically informally, through to their grandchildren through the biological parents. Now, if the parents are still together and they are preventing the grandparents from having access, or the parties are separated and one or both of the parents is preventing access, grandparents may have certain rights in the state of New York. So let's start with the right to visitation. So in order to establish the right of visitation and ask the court for permission to set a visitation schedule with grandchildren, the grandparent or grandparent's burden of proof is to show a couple of things. One is that there is a well-established pre-existing relationship with the grandchildren. Now, if you have newborn grandchildren or very young grandchildren, there may be a different level of burden of proof because you maybe haven't had a long time to establish a relationship. But the older the children are, the more you have to demonstrate that you've had an ongoing, consistent, pre-established relationship that at some point in time got interrupted by the biological parents or one or both of them. Then the next thing you have to establish, if you can show you have a pre-established existing relationship with grandchildren, is that it's in the grandchildren's best interest for that visitation and contact and ongoing relationship to continue. So those are your two-step burden of proof hurdles to get over if you're going to ask the court to intervene and grant you visitation rights. Now, sometimes grandparents are wondering, are there circumstances under which I would be entitled to or should be considering pursuing custody of my grandchildren? And let me just take that as a separate kind of inquiry. So, under certain circumstances, grandparents may have rights to obtain custody of grandchildren. And the threshold level of proof is higher in those situations because there we're talking about taking over custody of grandchildren from the biological parent or parents. And at least in New York, but certainly across the United States, there's a well-established constitutional underpinning to the right to raise your children, and in New York it's included in our state constitution as well. So we don't lightly take custody away from biological or natural parents and endow that or grant that to anyone else, even a close relative like a grandparent. However, in certain circumstances in New York, if you can demonstrate that there are extraordinary or exceptional circumstances that equity would see fit for the court to intervene and interrupt the natural parents' rights to raise their children, then a grandparent might have standing to get custody. So you have to show this exceptional or extraordinary level of circumstances that equity would warrant a court getting involved in disturbing the natural parents' endowed rights, and that it's in the best interest of the children that the grandparent or grandparents who are petitioning the court be awarded custody of their children. Now, it's not really the focus of my informational session with you today, but there is another set of circumstances under which sometimes grandparents are asked, in fact, by official agencies to step in and take custody and care of grandchildren. And that might be when a Department of Social Services Child Protective Services unit files a petition against one or both parents, indicating that the parents are abusive or neglectful and that the child or children need to be removed from the care of the neglectful or abusive parents. And they're looking for suitable relatives to take custody and care of the children. And that might be on a temporary basis. And in some instances, if the natural parents aren't able to regain their full parental and custodial rights, then grandparents might be in a position to take custody as a resolution to that on a long-term basis, or even to adopt grandchildren as a permanent resource and placement for children whose parents have demonstrated that they are not likely to regain their parental rights in a suitable way. So those are really the three sets of circumstances whereupon grandparents might be entering into the court system for visitation, custody, or even adoption rights over grandchildren. So I hope that brief overview has been very helpful. I have a number of questions from people who are joining in this today and had registered and pre-submitted questions, and I do encourage you to submit others as we go along. If you are on live with us and you didn't have a chance to submit a question in advance, and we'll try to get all of the questions answered during our time together today. So first is a question from a viewer who asks, can I file for visitation if the parents are still together? And the answer is yes. And I have to say that more often grandparents come to access legal services from my law firm when the parents are separated and they are being denied access by one or both of the parents, and they are looking to understand their visitation rights or potentially petition. But it is true that even if the parents are together, if they are both refusing steadfastly to allow grandparents to have access, when those grandparents have demonstrated or can demonstrate that they had a pre-existing relationship and bond with the grandchildren that has now been interrupted or terminated by the parents, they could potentially pursue visitation. Next question up from one of our viewers is, what will the court consider when deciding to grant a visitation request? So that's a great question, because other than the standard that I had expressed at the outset, that you need to show a pre-established positive relationship with the grandchild or grandchildren and that it's in the best interest, the door is wide open to the types of information that can be submitted in support of a grandparent visitation request. So if you are a petitioning grandparent, you're going to want to put forth as much information as possible, including as many details as you can, about the nature and quality of your existing relationship with your grandchild or grandchildren before it was interrupted. So if you haven't been doing so and you're thinking about whether you should be considering filing, you'll want to try to keep an ongoing journal log and calendar, or go back and try to recreate that from records that you might have already about the dates and times and duration of prior contacts with your grandchildren. And those would include things like FaceTime or Skype calls, phone calls, cards, letters, birthday gifts, Christmas gifts, Easter baskets, and anything else that you have done or shared with your grandchildren. Any photographs or videos that you have of positive interactions with the grandchildren would also be helpful. And of course, all communications, if you have memorialized them, perhaps you have recorded voicemails or text or email communications to and from the parents where you are communicating about the children, about requests for visitation, etc. All of that ideally would be brought to the attorney helping you if you're intending to petition for visitation, and the court will consider all of that. You should also know that the parents have the right to counter and have counsel in those proceedings as well, and so you might anticipate and try to prepare to counter any arguments or evidence that you think the parents are likely to put forth in the court proceeding. And then it's also very, very important to know that in any custody or visitation situation in a court, at least in New York, the children involved, or the children who are the subject of that proceeding, will have a court-appointed attorney. In New York, we call them an attorney for the child, and they are appointed by the court and paid for by the state court system. And that attorney will be meeting with the children no matter what their age or ability to verbalize or vocalize their opinions might be. So whether they're infants or they're 15 years old or 18 years old, or well, 17 and a half years old, their attorney will be reaching out to them and will be advocating for that child's particular position on the grandparent visitation. All right, the next question is, when do grandparents have the legal right to request court-ordered visitation? So as I indicated, the threshold is that pre-established, pre-existing relationship with the grandchildren, and a interference or complete block of access to their grandchildren by either or both of the biological parents. So those are the two prongs that you must satisfy in order to have standing to petition for visitation in New York State. Number 4, one of our viewers has asked, how much visitation can grandparents expect to get? And that's a great question. And like so many things in the family law, that's going to be really heavily dependent on the facts and circumstances of each family situation. So in some instances, grandparents might live next door or down the block or in the same regional community and have had regular, ongoing, consistent contact with their grandchildren. Maybe they've even had regular overnights with just the grandchildren, perhaps weekends, or having been allowed in the past to take children on trips or camping outings and things like that. In other situations, grandparents might be more geographically distant from where their grandchildren live, but nonetheless have had ongoing video communication or annual visitations or monthly visitations or summer visitations of some sort. So I think it's reasonable to assume that the kind of contact that the grandparents had when they were allowed regular contact is potentially within the realm of what a court would consider granting. And so again, I don't mean to not be very clear or specific on this, but I think it's going to depend on each unique situation and the history of the level of contact involvement the children have had with their grandparents. All right, one of our viewers asks, do I have rights if my grandchild is adopted? So I'm going to assume that this questioner is asking about if the grandchild was adopted by someone else, what are their rights? And the answer unfortunately, there is, you may not have any rights if your child was adopted by another individual or family, unless there was some sort of negotiated post-adoption contact between the biological grandparents and the new adoptive family or parents, or if the adoptive parents are willing to consider allowing the biological grandparent voluntarily to have some contact or access to information about their biological grandchild. But in the usual circumstance, if a child is adopted out of a family, then the adoptive family is standing in complete place of the original biological parent's family, and the biological grandparent may have no or very limited rights in those circumstances. The next question is how to go about getting custody or guardianship of my grandchild. So guardianship is a slightly different procedure, and I'm not really going to focus on that today because it's somewhat more technical, but often guardianship is used in limited basis, or there is a limited grant of authority to make decisions about the child in guardianship arrangements that are informal, meaning the parents are consenting to temporary guardianship, for instance, of the grandparents. I see this sometimes when one or both parents are deployed in the military and they need grandparents to take charge of the children while they are on active duty. They might grant temporary guardianship and permission to make educational and medical decisions in those situations. But again, that's a different topic, and we're not really going to go fully into that today. And with respect to how do I get custody, I think I've already addressed that in my opening remarks, but you need to show extraordinary or exceptional circumstances under which equity would deem it appropriate to interfere with the biological parents' natural rights as parents, and that it's in the best interests of the grandparents to have custody awarded to them. The next question is, what if the custodial parent is opposed? So I may have touched on this, but it's a great question, and I want to be really clear that because this is such an important right, natural parents are endowed with the right to raise their children. And so someone coming in, even a close relative like a grandparent, seeking to get custody over the natural rights of a biological parent has a pretty high burden of proof. And I mentioned earlier that in any proceeding like this, the child or children would have a court-appointed attorney representing their interess, and both of the parents would be entitled to notice, an opportunity to participate in, and that might mean object to the grandparent's application for custody or visitation. And they have the right to have counsel. If they income qualify, they have the right to have a court-appointed attorney in New York representing them and potentially interposing opposition to the grandparents' requests. The next question is, what does the court consider when determining best interest? So that's also a very logical and a good question. It's also one that's really hard to answer because best interest is so broad. I mean, it's, I think, intentional that our standard for determining these things is so broad because it gives the court great latitude and ability to consider wide-ranging types of information. So they might consider who's the most emotionally equipped to support a child or children, who's got the best ability to address special needs, if any, of any children, what are the economics of the potential households, what about sibling contact and half-sibling contact if siblings are spread out among multiple households. Certainly would siblings be split up if there was an award of custody or visitation to the grandparents. So it's a whole host of things, but it's basically anything that touches on the emotional well-being, the health, the welfare, the religion and the education, and the economic circumstances of the children involved. So I'm sorry I can't be any more specific than that, but suffice it to say that I feel that most family court judges who are making any decision about what's in the best interest of a child or children is looking to gather as much relevant information as possible so they can be confident that whatever outcome or decision that they make in that particular case for those children is made on the best and most reliable and most complete amount of information available. And that's why I suggest that if you're going to petition, that you're going to want an experienced attorney who understands grandparents' rights and has a track record of pursuing these matters, and you're going to want to assist that attorney by providing as much evidence and information as you possibly can in order to help that attorney meet those threshold burdens of proof about extraordinary circumstances and best interests of your grandchildren. The next question is court required when seeking visitation of grandchildren's, or is it possible to mediate this? And I love this question. The mediator in me says, I'm so thankful to whoever asked this question, because obviously, if you want visitation of your grandchildren, I would hope that you want to have at least a civil and respectful relationship with the child's parents. And the best possible way to ensure that that happens, is developed, or continues if you already feel like you have a good working relationship with the parents, is to try to mediate it and come to an out-of-court resolution. Once you have an out-of-court resolution, you may elect to ask a court to approve that resolution and turn it into an order of visitation or custody, as the case may be. But it's not required, and sometimes parties are quite content to just have a written agreement that they have all signed on to follow and control how they will share time with the grandchildren. There's a question from one of our viewers today that says, what happens if a child is placed into foster care? Can we still apply for visitation rights and custody? And the answer is very likely yes. And if the child is placed into foster care, you should be aware that, at least insofar as New York is concerned, the local Department of Social Services who has taken the child into foster care has a duty to try to identify, locate, and do background investigations on or inquire about the suitability and willingness of any relatives of the child or children in foster care, and those individuals are to be considered. You can also, even if the Department of Social Services isn't asking you or endorsing you to take placement of children who have been removed into Department of Social Services foster care, you can apply to intervene in the ongoing court proceedings for abuse and neglect as an interested party and assert yourself as a potential custodial resource or as somebody who would like visitation of children who are in foster care. Or you could file your own custody visitation petition alongside whatever is going on with the legal proceedings that resulted in the Department of Social Services taking the grandchildren into foster care. So there's a question akin to one that we had a little while ago, but it asked, what does a visitation with grandparents, a visitation schedule look like? So as I indicated, that's going to be very fact-specific based on the particular facts and circumstances and history of the particular family and the grandparents' involvement with the grandchildren. But suffice it to say, if you are asking for visitation and not custody, don't expect to have a custody-like schedule. Don't expect, unless the parents are willing, to split the week with you or give you every other weekend necessarily, unless that has customarily been what has happened voluntarily before the parents change their mind and switch gears on you. So, but beyond that, it's hard for me to generalize. I have some grandparents who might have several hours or even an overnight or a weekend a month, and others that have it restricted to holiday time and perhaps when the children are not in school in the summer, if those grandparents don't live in the same geographic region as their grandchildren. So the next question is, what forms do I need to file a petition, and how much will it cost to file? So to be perfectly honest with you, New York has a bank of forms that you can get at every family court clerk's office. You could find forms for emergency applications. Let's say you feel like your grandchildren are in an unsafe situation and the court needs to act very quickly to protect them. You can find forms to fill out for custody of children or for visitation of children. But understand that those are mostly designed for use by parents. And so they're not quite tailored to the asking you to fill in the form in a way that elicits or invites you to put into that application the threshold information that I have described that you need to actually have your petition be considered by the court. So you perhaps are better off in other than emergency situations to consult an attorney and ask for assistance in preparing your petition. But you should know that you could try the forms that are available. They're also available online, and I will ask my support team to put in the comments how you access, but it's the New York State Court site is www.courts with an S, courts.state.ny.us. And if you go to the homepage of the New York State Court System at that address and click the tab for forms and then click for family court forms, you'll find some specific forms available for you there. You can download and print them in blank, or some of them are fillable online, and then you can print out your completed form after you type in the appropriate information. If you do choose to represent yourself, understand that unless you already have an order of custody giving you custody of your grandchildren, you would not apply for free representation even if you income qualified otherwise. So it would be advisable for you to try to engage counsel to assist you with it. And how much that costs you is really hard for me to predict. It depends on how much time the attorney would have to put into representing you in that matter. If there is lots of opposition from one or both parents, or lots of court appearances, or even a full trial in order for the court to determine what the best outcome is, that's going to have a much higher price tag than if you have help filing a petition and you work something out to everybody's satisfaction at the first or second appearance in court on the matter. That's going to be a much less or much lower economic investment. But if you really do want to understand the scope of your particular situation, and you are located in New York and in the counties that my law firm potentially serves, we would be happy to consult with you and give you a better assessment of what it would take in terms of legal work and potential costs in your particular situation. So don't hesitate to reach out to us. We would be glad to give you some one-on-one assistance and individualized advice. But as I stated at the outset, that this is not a forum for giving you specific legal advice and understanding your situation. It's really for me to answer a few questions for you all and to provide enough information so you have an understanding of your rights to know when it's appropriate to potentially get a more in-depth legal consultation about your unique situation. Someone has asked if after you go to court you disagree with the court's decision, can you file an appeal? That's also a really good question, and it's one that's not really often asked in these forums. So I'm pleased that somebody had asked it here. So you should know that every family court decision that, in theory, that is issued and signed by a judge, or every order signed by a judge at a family court, is subject to potentially being appealed. Now, there's some big differences about whether you consented to something and settled, and the settlement got turned into an order, and whether you had a contested hearing or a trial and the judge made a ruling and a decision after hearing all the evidence. So chances are, if you consented to an outcome by way of a settlement agreement that gets turned into an order, or agreeing to a proposal in court that the judge adopts as the order in that particular case, your appeal is not likely to be successful because you knowingly consented. So we would sometimes say that that's maybe perhaps buyer's remorse or next day regrets if you rethink whether you should have agreed to that outcome or not. So those are not likely to be worth pursuing, even though you technically could try to appeal it. Anytime there's a ruling from a court after a full evidentiary hearing and without the consent of all the parties, meaning you just waited for the judge's decision and the judge made a decision, you have a right to appeal. You have a certain time period within which to appeal. So generally that would be 30 days from the date you learned of an order in open court, if you were standing in court when the judge made his or her decision or ruling, or 35 days if the order was mailed to you or sent to you by electronic means at the conclusion of the proceedings that resulted in that order. Appeal is a very involved in technical process, so you would definitely be well advised to consult an attorney about your rights to appeal and whether or not the attorney thinks there is merit to pursuing the appeal. But keep in mind those time frames of 30 or 35 days from the date of a judge's order to make that decision. So you might want to quickly get a consultation and get that notice of appeal filed, even if the ultimate decision is you don't pursue the appeal. You have to get the notice of appeal in there in the right time frame, or you would potentially forever lose your right to appeal a decision from a court. All right, someone who I'm going to assume is a grandparent asks, is it possible for me to have rights to the kids if the father doesn't? So I'm going to assume that this person is a relative of the father's. Maybe this is the father's mother and father, or mother or father. So yes, that's a perfect example of when you might apply for access to your grandchildren, because normally we presume that grandparents get access through their own biological child. So I was going to use my example. So if my parents wanted access to my children, they could ask my husband, but legally we would assume that they would go through me. The connection to their grandchildren is through me, their daughter. So if I had no rights, they would have no ability to go through me to access their grandchildren. And so they could ask my husband, but technically if they have no rights or no access to the children because their own biological son or daughter doesn't have access to their own children, that could be a potential situation where they could petition for visitation or possibly even custody, depending on the circumstances of the other parent. The next question from one of our viewers is, how do I make sure grandparents' rights are enforced? And what can I do to file an enforcement action? So if you have rights by way of an agreement or a court order, you absolutely have the right to use the courts to enforce that. So if you have an agreement that is not a court order, you handled it out of court and you mediated and you have a proper written agreement with everybody's signature in the presence of a notary, or acknowledged in the presence of a notary, you could enforce that as a contract. All agreements who meet those requirements, they're in writing, signed by the parties in the presence of or acknowledged before a notary, they're enforceable agreements. If you have a court order of visitation or custody and one or both of the biological parents are not complying with all of the terms of that order, you absolutely have the right to file a petition to enforce your rights under that order. And with court-ordered obligations, the party who is violating the court order, if that's found to be the case, is potentially in contempt of court, which has serious sanctions associated with it. So the sanctions could include that they pay your legal fees because they were in contempt of court and violated the order willfully. For willful disobedience of an order, they could be sanctioned with a fine by the court. They could be in serious or protracted or very, very egregious situations, potentially even incarcerated as a penalty for contempt of court. But more often than not, if you're just looking to enforce your rights to visitation or access to the children, bringing the other, the breaching party or the non-compliant party to court is a perfectly appropriate and productive way to get the court to require that valid orders of the court are filed by all parties, or followed by all parties that are touched by that order. So the next question was, what happens if parents violate grandparents' rights in an order? And I've just laid that out for you, right? So there's enforcement and there's contempt as a penalty if people don't follow court orders. Someone has asked, what's the difference between physical and legal custody? That's a great question. In New York, there really are those two elements of custody. And when I describe this, I'm really talking about custody rights of the natural parents of a child. So natural parents who are no longer living together or working together to raise the children cooperatively and find themselves in court or in need of a custody and visitation order should know that the legal custody component involves the right of both parents to be involved in important decisions touching on the upbringing of children. So things like health, education, welfare, religion, and if you think about it, anything that requires parental consent. So if you think about forms that you would sign or permissions you would have to grant formally for things involving your children, and I'm going to be kind of mundane here, but piercing their ears or other body parts before they're 18, or getting a tattoo before they're 18 requires parental consent. Those are the kinds of legal rights that parents have to be involved in. And so we assume that most parents would enjoy joint legal custody rights, meaning that they would have the opportunity to be involved in and the obligation actually to confer, discuss, and reach agreement on all of those things that require parental consent. So that's the legal component, and there really are two variations. One is the parties sharing joint legal custody, and the other, one parent having sole legal custody. Sole legal is considered appropriate when the parents don't see eye to eye on anything and they just always fight. Sole legal may be appropriate when the parents have no ability to communicate, such as when one party is incarcerated, or one party refuses to communicate with the other, or there are orders of protection in place that prohibit any form of communication between the parties. They obviously can't carry out joint legal custody if they can't confer, discuss, and try to reach agreement on issues touching on the health, education, welfare, and upbringing of the child or children that they share in common. And then there is the other component of custody. We used to say it's physical custody, or somebody gets physical custody and the other parent gets visitation. We've moved away from that in recent years, and we really just refer to the physical custody element as where are the children spending time and on what schedule. So I prefer to call that or use the phrase the parenting schedule as an umbrella phrase for that. So the parenting schedule may be such that one parent does principally have the children most of the time in their household and the other parent has the child or children less. The custody schedule could be exactly 50-50 equal placement, and it can be any variety or variation thereof. But we generally say now that we have, legal custody and parenting time. And those are two different elements of custody that are addressed between the parents. Now, grandparents may in some instances end up sharing custody with one or both parents, and there can be a lot of reasons why that is. And if that's the case, they may be sharing legal custody, which means they all have to communicate and agree about decisions concerning the children. And in many situations, that may be the appropriate outcome, is that the parents still maintain their legal custody rights, but the grandparents are involved in the decision-making and have regular parenting time or grandparenting time with the children, while the parents may continue to have regular parenting time as well, or ongoing routine parenting time with the children. Those are more of what I like to call the it takes a village kinds of arrangements, where grandparents are regular involved players in upbringing of the grandchildren together with one or both of the parents for a variety of reasons. who can request a visitation order? So generally, in New York, let's just maybe start there. In New York, we have a statute that allows expressly for grandparents under the circumstances that I described, where they can show a pre-existing positive established relationship with the grandchildren that has been interrupted by the parents wrongfully, and that it's in the best interest of visitation between the grandparent and the grandchild to continue. There's a statute that endows grandparents with that right. As for other relatives, it's a little less straightforward, although there are plenty of cases that have gone through our court system where close relatives like aunts or uncles may have had assumed a regular role in assisting with the upbringing of the children, or had regular ongoing contact, who have had success in getting visitation orders. If that's your situation, where you are not a grandparent but you are somebody close to a child, if you are a blood relative, there may be a basis to pursue something in court. If you are not, then your avenue is trying to work with the parents to get some sort of agreement in place, and mediation could be a good option for all of you in that situation. So I had described earlier that this our law in New York with respect to grandparents gaining custody rights over grandchildren has a threshold of a showing of unusual, exceptional, or extraordinary circumstances such that the interests of equity deem it appropriate for the court to intervene. That means that I guess it's a phrase that indicates that grandparents don't have an absolute right to seek custody, but if the circumstances require, if equity or fairness or the appropriateness of the needs of these children require or compel, I would say it goes almost as strongly as compel the court to intervene. That's what we're talking about there. And that phrase is intentional, and it's meant to underscore the fact that courts shouldn't just willy-nilly interfere with the natural parents' rights to raise their children, that it has to be something pretty exceptional, extreme. And moreover, it's really not a test of, do the grandparents have more money, more time, more resources? Are they better custodial options than the parents? It's not about who's the best option, because look, none of us are the best parent in the world. None of us are flawless. I know I'm not, and I have met lots of parents and worked with lots of parents, and none of those are flawless either or perfect. So it's not about whether the grandparents think or can demonstrate that they offer more resources to a grandchild or are better suited to raise the children. In our courts, at least in New York, we say that children are entitled to good enough parents. And so unless the grandparents can demonstrate that the parents aren't good enough parents, in fact that they are seriously flawed and faulty parents, is what you need to prove, grandparents would not be awarded custody of grandchildren simply because they can demonstrate that they could do a better job than the parents have been doing to date. So that's where we are in terms of questions, and we're wrapping up a little bit early. I was going to take a look. I don't think that there have been other questions submitted, but I just want to double check. But if that is the case, you've bought back 15 minutes perhaps of your lunch hour to go take a walk or grab a snack or a drink before you get on with the rest of your day. I hope that you have found this informative. Please do remember that we are here for you. You can reach us. There'll be contact information in the comments on how to hop onto our website. Feel free to download from our website our free resource guide to understanding your rights as a grandparent. We'd love to hear from you if you're in New York and you would like to consult. And just wanted to finish up by telling you that you can check back on our WhitsonLawFirm.com Facebook page, which is, I assume, where you found us. If you are aware of and attending this presentation. We try to do these monthly. The topic changes from month to month, but please do spread the word. If you found this helpful, share with others. The recording will be available. And in addition to the free resource guide on grandparents' rights that you can download at our website, we have a host of other resources about child custody, about getting your estate plan in order, about divorce. You can even download my newly available book, Divorce Like a Pro, A Better Way to Break Up. Spread the word. We're here to help, and hope we hear from you soon. Thanks, everybody, for joining us today. Have a great rest of your Monday and a good week ahead.